Good morning. I'd like to welcome you to the third session of our MCLE CPD week of virtual sessions. We're running 2 sessions per day this week, including the 3 mandatory topics. I hope that you'll be able to attend our complimentary sessions this week to ensure you obtain your CPD points. Before we start our session this morning, I'd like to acknowledge the traditional owners of the land on which we meet today. I would also like to pay my respects to elders past, present and emerging. With that, I'd like to introduce myself and my guest speaker this morning. My name's Peter Lucarelli. I'm a partner of Baker & McKenzie in the dispute resolution and restructuring insolvency practice groups. And I'm joined this morning by my senior associate, Jessica Arscott. Our topic this morning relates to the small business insolvency reforms, which have been quite topical both last year during the height of the COVID-19 pandemic and into this year and continuing. We've got a pretty full agenda this morning, which we've summarised in the slide which appears in front of you at the moment. What I thought I'd start off with is providing you with a very brief overview of the changes to the law which occurred on the 1st of January 2021 relating to insolvency relief. You may recall that towards the end of March last year, on the 25th of March, the federal government enacted legislation pursuant to the Coronavirus Economic Response Package, the Omnibus Act 2020, in order to provide temporary relief for companies due to what was then emerging as the COVID-19 pandemic. That temporary relief ended on the 31st of December 2020. Relevantly, what it included was measures to provide directors with insolvent trading safe harbour during that relevant period to ensure that companies and directors that were allowing their companies to continue to trade during the pandemic couldn't be held liable personally for insolvent trading. The other measures included increasing the thresholds for statutory demands from what was then $2,000 to $20,000, and more significantly, the period to respond to any statutory demand was increased from 21 days to 6 months. Those measures came to an end at midnight on the 31st of December 2020, and in its place, what the government did was enacted legislation to introduce effectively a debtor in possession restructuring process for small business, for small companies. And that new restructuring process regime commenced on the 1st of January 2021. At the same time, the government announced and enacted legislation to provide for temporary relief for entities that were trying to access this new restructuring process, which we'll go through this morning, and that temporary relief will come to an end on the 31st of March this month, with the possibility of a further 1-month extension. The last set of reforms that were enacted and came into effect on the 1st of January this year was a new simplified liquidation process for small companies, and that's an alternative to the traditional form of voluntary liquidation, which we'll also cover off this morning. As we move to the next slide, what we've done there is summarised, or at least identified, the key pieces of legislation and regulations and rules where these new reforms sit. They're predominantly found in a new part to the Corporations Act, Part 5.3, that deals with the restructuring process, supplemented by a detailed set of regulations found in the Corporations Act dealing with Part 5.3, and then there's numerous changes that have been made to the insolvency practice rules in order to give effect to these changes to the law. So this all kicked off on the 1st of January 2021. So we're about sort of 10 weeks into the new regime, and so far what we've seen is a slow uptake in terms of the new restructuring process for eligible companies. As of today, I think as of this morning, Jessica assures me that we've been able to identify 19 instances where small businesses have given notice to ASIC that they're eligible for temporary restructuring relief. That's the temporary relief that's available until the 31st of March. And there's also, we're aware of 5 appointments of restructuring practitioners under this new restructuring process. So not a huge uptake so far, not surprising. It's only a new regime that's come into effect. It takes time for industry participants, companies, practitioners, lawyers, etc., to really get their head around the new process and how it might be able to be used. But not surprisingly, notwithstanding there's only been 5 formal appointments of restructuring practitioners over the last 10 weeks, we've already had 2 decisions from the Victorian Supreme Court, and we've identified those there at the bottom of the slide. Those cases concerned whether or not two different companies having commenced their restructuring process ought to be subject to winding up applications, which were commenced at about the same time. And in each instance, the court formed the view that it was in the best interest of the company's creditors for the winding up application not to proceed, in order to give the company the opportunity and for the company's creditors to engage with the restructuring process. So next slide. So what is this restructuring process that I keep referring to in a nutshell? It's a procedure which I said commenced on the 1st of January and with some transitional provisions until the end of this month. It's a framework for eligible companies to work with a restructuring practitioner to develop and propose to creditors of the company a debt restructuring plan, which, if accepted, will bind the company and certain of the company's creditors. The process is available to companies with total liabilities of less than $1 million. Companies that have liabilities in excess of that amount therefore aren't able to avail themselves of this particular restructuring process. Our view is that the threshold is quite low, and I think that's been done purposefully by the government in order to at least enable this new restructuring process and plan process to be enacted to provide industry really with an opportunity to assess the effectiveness of it. And there's certainly the scope for the Treasurer by regulation to increase the availability of this process by increasing the liability threshold from the 1 million, which we may see in time. This new restructuring process has been described as a debtor in possession type model, and that's on the basis that once the company via its directors commence the process, the company through its directors retain control of the company. And that's in stark contrast to the voluntary administration process that many of you will be familiar with. In the case of a voluntary administration, once the administrator is appointed, directors' powers are suspended and control of the company is put into the hands of the administrators. This restructuring process is, as I said, the opposite of that. In terms of assessing whether a company's liabilities are less than $1 million, regard must be had to contingent liabilities. And that was one aspect of the 2 cases which we showed a moment ago. In one of those 2 cases, the court was satisfied that in assessing the eligibility of a company for this new restructuring process, contingent liabilities have to be estimated by the restructuring practitioner and taken into account in determining whether that threshold of 1 million is met or not. Once the company that is eligible for restructuring commences the process, it provides an immediate insolvent trading safe harbour for directors. So that's one of the benefits for directors in order to really encourage them to commence the process. The whole design of the restructuring process is to provide a faster, more cost-effective alternative to voluntary administration. Government's formed the view that whilst voluntary administration is a very effective tool to restructure companies, it tends to be really only effective for those companies that can afford what is considered the high cost of the voluntary administration process itself. So this is meant to be a faster, streamlined and more cost-effective way for insolvent companies to deal with their creditors. Overall, the process is designed to be completed within 35 to 45 business days. That's for the restructuring process itself. At that point, if creditors approve what is proposed, then a plan comes into effect, and that plan can be implemented for up to 3 years. During the process, there's no personal liability for the restructuring practitioner, provided that that person acts in good faith. There's been some commentary that the process could be abused, but I guess only time will tell as to whether that's in fact what ends up transpiring, although there are numerous safeguards set out in the in part 5.3b and the regulations to try and prevent that from occurring. So moving to the next slide, and I might at this point hand over to Jessica, who's going to walk through what are the 2 key phases of the restructuring process.
Sure.
Thanks, Jess.
Thanks, Peter. So we're just going to give you a very quick bird's eye view of how the process works, so that when we go into a bit of the detail later in the presentation, you'll have a bit of context as to where everything sort of fits in. Now, the restructuring process itself sort of falls into 2 phases, very similar to with administration, where you have the administration and the docker phase. Very similar with part 5.3b, you've got a restructuring phase and then a plan phase. Now, a company enters the restructuring phase when it appoints a restructuring practitioner to the company. That's a fairly simple process. Essentially, the restructuring practitioner will consent to act. The company's board will pass a resolution that the company is insolvent or likely to become insolvent, and that the the restructuring practitioner should be appointed. And then finally, there'd be an instrument of appointment, which is basically just a very short document whereby the company formally appoints the restructuring practitioner. It's very shortly after they're appointed, the restructuring practitioner will then send an initial notice of their appointment to both ASIC and creditors. Creditors will also receive certain information about how the process works. So this is often where creditors will first hear about the fact that the company is undergoing one of these processes. In addition, the director will give a declaration to the restructuring practitioner. That's essentially a declaration that, in the director's view, the company is eligible to access this process, and in addition, that there haven't been that the company has not entered into any type of avoidable transactions, excluding their preferences. We'll come to that in a bit further detail later. Okay, so once the appointment occurs, the company then has 20 business days or a proposal period to develop, execute, and deliver to the restructuring practitioner what's known as a restructuring plan. We'll go into the detail of what a restructuring plan can and can't do a little bit further down the track. But critically, before that restructuring plan can be sent off to creditors, the restructuring practitioner would have to make a declaration that, in its view, the company will be able to, amongst other things, satisfy all of the obligations under that plan. And in addition, the restructuring practitioner would need to be of the view that the company is eligible again to access the procedure. Importantly also, and this is something that's very important for companies to consider if they're considering accessing this process, is before that plan can be sent out to creditors, the company will need to have paid all of its employee entitlements, and in addition will have to be up to date with all of its tax lodgements. Now, that's often seen as a bit of a barrier to companies accessing this process. However, it is the government is very, very concerned to make sure that employees are well looked after. So yeah, that's certainly a high threshold that companies will need to meet. Then once the restructuring plan has been sent out to creditors, creditors will have up to 15 business days to vote on the plan. And in addition, if they dispute the company's assessment of quantum of their claim and or whether they're an excluded creditor, then they'll have 5 business days to dispute that. We'll come to the dispute process a little bit further. Again, just very much a high level. So yeah, 15 business days to vote on the plan essentially. Assuming that plan is accepted, the plan will be taken to be made and the restructuring phase technically ends. The restructuring practitioner would have to give a notice to creditors that the plan, and notice to creditors and ASIC that the plan has been made, and a copy of that plan would also need to be lodged with ASIC. Then once you're in plan phase, the the restructuring practitioner will assist the company in implementing that plan, making distributions to creditors, and then once all of the obligations of the company under that plan have been satisfied, the plan will terminate, and that's when you exit plan phase as well. Now, it is possible for the restructuring phase to end early. The key one is where the company has entered this restructuring process but fails to propose a plan to creditors within the 20 business day proposal period. In addition, if the plan is not accepted by creditors, in those circumstances also the restructuring phase would also end. In addition, if the directors decide that they want to exit the process, they can make a declaration that it will come to an end. In addition, if the restructuring practitioner identifies anything sort of dodgy going on, it can cancel the proposal, also terminate the restructuring process. In addition, it's possible for the restructuring process to be ended early by a court order, or in circumstances where an administrator or a liquidator is appointed. That's a very bird's eye, high level canter through the restructuring process, but I'll hand back to Peter now.
Thanks for that, Jess. Before I get on to the next slide, we've had a couple of questions. One was to do with the position of landlords and tenants, which we'll come to during the course of the presentation. There's a question also, quite an interesting question, and thank you for it, Justin. It's to do with whether or not secured creditors ought to, in effect, seek the agreement of the restructuring practitioner to extend the decision period, which is generally 13 business days from the date of the appointment of the restructuring practitioner before the secured creditor can enforce the security. Certainly, Justin, I think that's something which a secured creditor ought to consider, and if appropriate, seek the consent of the restructuring practitioner to, in effect, extend that time period so that the secured creditor can carefully monitor the restructuring process to ensure that the plan which is put forward doesn't seek to jeopardise or compromise the position of the secured creditor. We'll get into more detail, and as to whether or not a practitioner is likely to provide that consent, obviously that'll depend on a case-by-case basis, but we'll touch on the position of secured creditors a little more during the course of the presentation. I've also had a question from Savvy wanting to know whether this new restructuring process is available to for-profit or is it also available to not-for-profit organisations. I think it's fair to say that the process is available to companies registered under the Corporations Act. So I'm not sure that would exclude not-for-profit companies from availing themselves of the process, provided that they meet the eligibility criteria, which we've briefly looked at this morning. So with that, I might move on to the next slide. As Jess has already mentioned, there's two phases to the process. One can't really get to the first phase unless they satisfy the relevant eligibility criteria. And first and foremost is that the company must have total liabilities of less than $1 million. And liabilities picks up the meaning from the Corporations Act, Section 553, subsection 1, and it's any debts or claims that would be admissible to proof in a hypothetical winding up of the company. And as Jess mentioned, it must necessarily exclude employee entitlements on the basis that those entitlements which are payable must have been paid in full in order for a company to be eligible. It otherwise excludes any debts that are incurred during a deed of company arrangement that would otherwise be admissible. The other criteria are that no director or a previous director of the company has been a director that's availed themselves of this restructuring process or the simplified liquidation process within the last 7 years, unless it's in respect of a related company which has commenced that restructuring process within the last 20 business days. And really the aim here is to avoid phoenixing type activity where this restructuring process is used mischievously by company directors to try and phoenix companies from one to another. And then the third criteria is that the company itself has not engaged in this process or in a simplified liquidation process within the last 7 years. As part of the eligibility, the company's directors are required to make a director's declaration, which is punishable by offence to the extent that the declaration is false. And they need to state that the company has not entered into any voidable transactions prior to commencing the process. That excludes any unfair preferences. And as Jess mentioned, again, the criteria for eligibility is that the company must have paid employee entitlements which are payable and otherwise, as well as having lodged all relevant tax returns, which is quite an onerous requirement for the companies to achieve. And then in terms of how the process commences, the restructuring practitioner is required to sign a consent, and the board of directors of the company in effect pass a resolution to the effect that the company is insolvent or likely to become insolvent, and that the restructuring practitioner ought to be appointed. Once that declaration is passed or declaration is made and the restructuring practitioner has signed the consent, then the company signs the instrument of appointment. Next slide. So the process works with the appointment of a restructuring practitioner. A restructuring practitioner will be a registered liquidator. The federal government at the time that they announced this new restructuring process had in mind that there'd be an avalanche of small business insolvencies due to the COVID pandemic, and so they thought it was appropriate to introduce a new class of restructuring practitioner only. So these are registered liquidators who would only perform the role of a restructuring practitioner and otherwise wouldn't be entitled to be appointed, for example, as a liquidator in the traditional way or an administrator, etc. The insolvency practice rules deal with the requirements for someone to be in effect registered as a restructuring practitioner, registered accountants with a demonstrated capacity to perform the functions of a restructuring practitioner, and otherwise that person needs to be able to comply with the relevant conditions in the insolvency practice schedules. And as I mentioned a moment ago, any person wishing to accept an appointment must consent to being so appointed in writing. Continuing on the theme of the restructuring practitioner, this slide sets out what the powers, functions and duties of that person are during the course of the restructuring, the two restructuring phases, both the restructuring process itself and then the restructuring plan. They're all set out in relevant provisions of the Corporations Act and the Corporations Regulations dealing with Part 5.3b. And on the slide, we've set out what those duties and functions are, depending on whether we're in the restructuring phase or in the plan phase. But essentially, the restructuring practitioner doesn't take control of the assets or the affairs of the company, but is there to assist and advise the company and its board in regard to the restructuring process itself, to investigate the affairs for the purpose of performing his functions or her functions, communicating with creditors in particular, including what the nature of the restructuring plan is going to be, and providing creditors with details of what the restructuring practitioner understands to be the debts and liabilities of those creditors, and significantly to terminate the process if the restructuring practitioner forms a view that the company either was not properly eligible to commence the process or is no longer eligible because of something which has been identified in the course of the process. So I'll hand over again to Jess, who's going to continue explaining the restructuring plan.
Sure, thanks, Peter. Okay, so as mentioned, once a restructuring practitioner is appointed, the company has 20 business days to develop and execute a restructuring plan with the assistance of the restructuring practitioner. Now, the Act basically provides a bit of guidance as to what a restructuring plan can and cannot do. Importantly, a restructuring plan has to be in approved form, and ASIC has released some approved forms on its website. essentially the way it works is your restructuring plan would identify the company, what company property is going to be made available to creditors, and set out basically how that property is going to be dealt with. Importantly, a restructuring plan does have to include some standard terms, and to the extent that the restructuring plan is inconsistent with those standard terms, it's taken to be void. Some of the key standard terms are that all admissible claims and debts are to be treated equally, and secured creditors will only be creditors for the purposes of the plan to the extent their security, that there is a deficiency in their security, i.e. they've got a claim for $500,000, but their security is only worth $200,000. They would only be a creditor for the purpose of the plan for $200,000. In addition, that plan would have to set out what remuneration the restructuring practitioner will receive during the plan phase. A restructuring plan may authorise the restructuring practitioner to do all of the work in connection with the plan. That may be selling companies' assets to get a big pot of cash to distribute to creditors. In addition, the restructuring plan can be conditional on certain CPs. Importantly, though, those CPs would have to be able to be satisfied within 10 business days of creditors accepting the plan. So it's not possible to propose a plan where CPs could only be satisfied sort of 6 months after acceptance. This is designed to be a very quick and fast process, and so the government certainly has kept that in mind in terms of thinking about CPs for implementation. Importantly, though, the plan must not provide, or basically must only provide for cash to be provided to creditors. It can't provide for, to discharge your debt, I'm going to give you 10 widgets. That's not a possibility. You can only give creditors cash. And in addition, the plan can only provide for distributions to creditors up to 3 years after the plan is technically made. In addition, the plan cannot release third-party claims like, claims of guarantors. Now, in addition, this restructuring plan has to be accompanied by what's called a restructuring proposal statement. Importantly, this document must include a schedule of claims. That's the company's assessment of what it owes to certain creditors. And so when you receive when one of these things comes across your desk, the first thing you want to look at is, what is the company's assessment of your claim? Is it, do you think that you're owed more? Are they treating you as an excluded creditor, which we'll come to in a moment? That's the first thing you want to check. In addition, once that plan has been executed by the company, it's provided to the restructuring practitioner, and they have to basically sign a declaration, which essentially states whether the restructuring practitioner believes on reasonable grounds that the company meets that eligibility criteria that Peter's already gone through, and that if the plan is made, the company is likely to be able to discharge its obligations under the plan as and when they become due and payable. And in addition, all information that's required to be set out in that restructuring proposal statement has been included. Now, the really critical thing to bear in mind with this declaration is that it's quite different from what creditors would receive in an administration. So normally in administration, you'd receive a report from the administrator that would include the administrator's opinion as to whether creditors will receive a better return in a liquidation the administrator would basically be required to form an opinion as to whether the return to creditors under a proposed DOCA would be greater or less than the return that they would receive in a liquidation. That's not required under this process. All that the declaration is a statement that the company meets the criteria, and critically that if it's implemented, the company will be able to comply with its obligations. Now, in formulating that and signing that declaration, the restructuring practitioner does have to make reasonable inquiries into the company's business, property, affairs, and financial circumstances. And to the extent it doesn't, then it can be taken to have committed an offence. Now, as mentioned, there are some standard terms that are incorporated into every restructuring plan. We've set them out on the slide there. But as mentioned, the really critical ones are that all admissible debts and claims will be treated equally, and a secured creditor will only be affected to the extent there is a deficiency in their security. Now, once the plan has been circulated to creditors, creditors essentially have 15 business days to vote on the plan as to whether to accept or reject it. And also, if they object to, and also 5 business days, generally speaking, to dispute the company's assessment of their admissible debt and whether or not they constitute an excluded creditor. Now, being an excluded creditor is quite a significant thing. When determining whether or not a plan has been accepted, the votes of excluded creditors are disregarded. Now, an excluded creditor is essentially the restructuring practitioner himself or herself, and anyone related to either the restructuring practitioner or the company. Now, this is obviously to make sure that companies don't put forward a plan that just looks after their mates, but instead puts forward a plan that is indeed fair. Now, a plan will be taken to be accepted if a simple majority in value of creditors who reply during that acceptance period vote to accept the plan. And generally speaking, the value of an affected creditor's vote will be determined by reference to the value of their admissible debt at the time the restructuring process began. Now, interestingly, for anyone who's in the business of buying and trading debt, one thing for you to be aware of is that where a entity becomes a creditor by virtue of having purchased another entity's debt, the value of that entity's vote will be determined by reference to the purchase value or the purchase price of that debt. So anyone like debt trading or debt collecting agencies that perhaps buy debt will only be able to the value of their vote will be referable to the purchase price which they paid for it, which is something which is quite different from what you have in administration, where you are always able to vote the value of your debt. Now, assuming you receive one of these restructuring plans and a restructuring proposal statement that includes a schedule of debt that indicates that you as a creditor, the value of your claim is less than what you were expected, there is a process for disputing the company's assessment of your claim. It's very, very important to act quickly because generally speaking, creditors, if they disagree with the company's assessment, they have to issue the restructuring practitioner with a dispute notice within 5 business days. It is possible for creditors to submit that notice late. However, the restructuring practitioner can disregard that dispute notice in circumstances where they're not satisfied with taking all reasonable steps to respond during that initial 5 business day period. Now, assuming you've submitted it on time, the restructuring practitioner will adjudicate your dispute notice and notify the company and creditor of its recommendation as to how it's going to resolve that dispute about the quantum or status of excluded creditors. Now, if the recommendation of the restructuring practitioner is to vary that schedule of claims, and that could, they have to sort of, the company is essentially required to vary that schedule of claims as soon as possible. Importantly, though, if the restructuring practitioner thinks that that variation is significant, they also have to notify the company and creditors of the variation and remind creditors that they can change their vote at any time prior to the acceptance period expiring. And that's important because if creditors suddenly thought that they were going to receive 80 cents in the dollar, and now because another creditor's been added to the list, they're only going to receive 60 cents in the dollar or perhaps 20 cents in the dollar, that may well affect their vote. So it's always important to keep an eye out if you're a creditor for what's known as a significant variation notice from your restructuring practitioner, because it may affect your return under the plan and how you would vote in respect of that plan. Now, if after that process a creditor remains dissatisfied with the restructuring practitioner's decision, there is an option of going to court and seeking an order and seeking further relief. Now, we'll probably now turn to what the effect of these processes are on some significant third parties in a company's world. Obviously, as we've already mentioned, company officers, directors have the benefit of some insolvent trading safe harbour whilst they're in the restructuring process or in the restructuring phase. However, once it tips into plan phase, that safe harbour ceases to apply. In addition, the directors remain in control of the company and retain all of their powers. That said, directors can't approve the company's entering into transactions that would affect the company's property outside the ordinary course of the company's business. The directors would need to seek the restructuring practitioner's approval or otherwise the court's leave. And importantly, if you are dealing with or transacting with a company in this process, you do need to assess whether or not the particular transaction that you're entering into is in the ordinary course, because if it's not, transactions will be void if restructuring practitioner consent isn't obtained. In addition, your directors have a duty to assist the restructuring practitioner by providing it with information about the company and giving an opportunity to inspect and take copies of the company's books. In addition, once it tips into plan phase, your directors will be bound by any obligations imposed on them under the plan. Members, there is generally speaking a stay whilst the company is in restructuring phase. They can't transfer any of their shares or alter the status of their shares unless they have the restructuring practitioner's consent or the leave of the court. Once it tips into plan phase, however, that stay lifts. Nevertheless, members will be bound by the plan. Secured creditors. This is a big one, and it's one that I think was highly negotiated, I think, between the banks and the federal government when this legislation was being considered. The restriction during your restructuring phase, it's actually quite similar to what you have under administration. There is a moratorium on enforcement that affects all creditors. However, there are some carve-outs for secured creditors. Importantly, secured creditors won't be bound by that carve-out in circumstances where they have security over the whole or substantially the whole of the company's assets and enforce their security interest within 13 business days, the decision period after the restructuring began. Now, I think there was a question about, whether it's going to be common for restructuring practitioners, secured creditors, to seek the equivalent of a 440B consent under an administration, i.e., I promise not to enforce my security interest during the restructuring phase, provided you agree that I can pick it up at another point. I expect that will be very common with these appointments as well. In addition, secured creditors won't be bound by that moratorium if their enforcement was already underway. That being said, the court can limit the power of the restructuring practitioner to continue that enforcement if satisfied that the secured party's interests will be adequately protected. And as I mentioned, secured creditors can also enforce where they've got the restructuring practitioner's consent or the leave of the court. And finally, if their security interest is over perishable property. In addition, however, that being said, the courts can order secured parties not to realise their security in circumstances where, on an RP's application, there is a view that the restructuring or the disposal of property would disrupt the restructuring process. Importantly, though, the creditor's interests would have to be adequately protected before a court would exercise that power. Secured creditors also have very similar voting rights to other unsecured creditors insofar as their debt is concerned. Once you tip into plan phase, however, that moratorium on enforcement lifts. Courts can still order secured parties not to realise their security. Importantly, though, secured creditors will only be bound by the plan if they consent to be bound. or their security is insufficient to cover their debt, in which case they would be bound to the extent they are not technically a secured creditor. There are also some limits on a restructuring practitioner's powers to deal with secured property during the plan phase, which we set up on the screen. Now, turning to owners and lessors. Very similar to the position that exists for owners and lessors under administration. There is a moratorium on enforcement, which means that owners and lessors cannot retake possession, carry out constraint, or enforce their security interests without the restructuring practitioner's consent or the leave of the court. Importantly, though, and in contrast to an administration, your restructuring practitioner is not personally liable for any rent that is payable in respect to the property during the restructuring phase. And that's really critical for owners and lessors to be aware of, because they will not, unlike they would be in an administration, for a certain period or certain, after the initial sort of rent-free period, owners and lessors cannot be assured that the rent referable to the restructuring phase would be payable as a priority expense in either the administration or subsequent liquidation. Once you tip into plan phase, the moratorium on enforcement lifts, and generally speaking, your property rights cannot be affected by the plan. You'll still be bound as a creditor to the extent you have a monetary claim against the company. However, a plan cannot affect an owner or lessor's property rights unless they voted in favour of the plan that actually, that purports to affect their right, their property rights. In addition, there are some limits on the restructuring practitioner's powers to deal with third-party property during the plan phase, which we've set out on the screen. Turning now to contract counterparties, very similar to what was introduced under the ipso facto laws in respect of administration, substantial receiverships, and also schemes of arrangement. There is also ipso facto protection for companies that entered this process as well. Essentially, amongst other things, these ipso facto provisions impose an automatic stay on counterparties enforcing against the company contractual rights and provisions that are triggered purely by the company being in a restructuring process or its financial position while it's in the restructuring process. There are, of course, a range of exclusions identical to the ones that apply in a administration, substantial receivership, and a scheme, but it's probably beyond the scope of this presentation to go through that. However, we have an excellent booklet on ipso facto laws, and so if any of you are interested, please do feel free to reach out. We're happy to share that with you. Now, once the company tips into plan phase, the ipso facto automatic stay lifts. Nevertheless, to the extent you are trying to exercise an ipso facto right that's referable to the fact that the company entered into the restructuring, you still can't, because the automatic stay that applies in the restructuring phase is actually permanent. Okay, so finally, assuming you've got your plan and it's all been voted up and it's approved, the next question is, how does this restructuring plan come to an end? And there are essentially 5 ways. The first one is satisfaction. Essentially, if all obligations of the company and other parties to the plan have been fulfilled, creditors' claims have been paid, the plan will terminate on the day that occurs. In addition, it's possible for a plan to be terminated early in circumstances where the court makes an order that it should be terminated early. There's been a failure of the CPs that we discussed earlier. There's been an unrectified breach that remains unrectified for 30 business days. Or alternatively, if an administrator or a liquidator is appointed. Okay, so we're now going to canter very, very quickly through the transitional temporary insolvency relief, which came into effect. I think, Peter, did you want to cover this, or shall I?
I'll just say something very briefly. Thanks, Jess. What the government did was to introduce temporary relief for companies seeking to avail themselves of this restructuring process. And this temporary relief is available until the end of March, and it requires an eligible company to an effective notice to ASIC, and for that notice to be published on ASIC's Insolvency Notices website, to the effect that the directors have formed the view that the company is an eligible company to avail itself of this restructuring process. That the board has resolved to appoint a restructuring practitioner, but that there's no restructuring practitioner or other insolvency practitioner that can be appointed. This temporary relief, in effect, provides the directors with relief from insolvent trading during the relevant 3-month period, which can be extended by up to 1 month, and it also has the effect of meaning that any creditor that wishes to serve a statutory demand on the company can't do so unless the amount of their debt is at least $20,000, and to the extent that a demand is served, the period for the company to respond to that demand increases to 6 months rather than the usual 21-day period. The reason this temporary relief was enacted was the government's concern at the time, towards the end of last year, that there'd be an avalanche of small businesses falling into insolvency come the 1st of January, and a lack of availability of a sufficient number of restructuring practitioners to accept appointments. That hasn't transpired. There's only been 19 of these particular notices that we've identified having been published on ASIC's Insolvency Notices website. So there's been a very, very small number of notices, given the millions of companies that would otherwise potentially, well, not millions, but certainly thousands of companies that might otherwise be able to access the the restructuring process. And so, given that this temporary relief will come to an end at the end of the month, really not much will come of it.
Cool.
So just moving on to the simplified liquidation process, which I'm going to hand over to Jess to cover, noting that we're getting towards the top of the hour.
Sure. Okay, we'll try and cover this as quickly as possible. Again, the simplified liquidation procedure commenced on the 1st of January. It's available to companies that meet certain eligibility criteria, including, importantly, having liabilities of less than $1 million. The idea with this process is we're trying to create a fast, less complex and cheaper alternative to a normal CVL, or creditors voluntary liquidation, and it basically operates by disapplying certain provisions that would otherwise apply in a normal liquidation. Importantly, though, there are some safeguards to prevent misuse, which we'll cover in this presentation. Now, the eligibility criteria are quite simple. Essentially, the way it works is the creditors voluntary liquidation would start in the normal course, and the liquidator may, if it thinks that the company satisfies the eligibility criteria, simply choose to adopt the simplified liquidation process if they believe on reasonable grounds that the company satisfies this criteria, namely that a triggering event has occurred, i.e. the company has entered into a creditor's voluntary liquidation. Secondly, the directors have given a report on company affairs and property, that as well as a declaration that the company will be eligible for this process. Thirdly, the company must be insolvent and not able to pay its debts in full within 12 months after the CVL commenced. And importantly, doesn't have liabilities exceeding $1 million, and neither the directors nor company have used the restructuring process or simplified liquidation within the preceding 7 years. Now, assuming you satisfy these eligibility criteria and the liquidator determines that it wants to adopt this simplified liquidation process, this is how the liquidation is taken to be simplified. Essentially, there are reduced investigation and reporting requirements. And importantly, from a creditor's perspective, there are reduced circumstances under which the liquidator can claw back unfair preferences. Now, an unfair preference in this simplified liquidation process will not be voidable where the relevant transaction is with an unrelated creditor and either occurred earlier than 3 months before the company entered the liquidation, or occurred during the 3 months leading up to the entry into the winding up process, and resulted in the creditors receiving less than $30,000. So that's, I think, going to reduce the amount of work that the liquidator has to do, but is also very important for creditors to be aware of, to the extent the company has adopted a simplified liquidation process, and nevertheless you do receive a notice from the liquidator, demanding the return of certain unfair preferences. First thing you want to consider is, are you a related entity of the creditor? Are you a related entity of the company? And do you satisfy? Do you fall into either of those two carve-outs? In addition, there are no meetings or a committee of inspection in a simplified liquidation, and there's also a simplified dividend and proof process. Now, given in particular the reduced circumstances on which unfair preferences can be clawed back, it's important to remember that there are some safeguards for preventing misuse. Firstly, your directors, when the company enters into a creditor's voluntary liquidation, the directors have to, within 5 business days of that commencement, give the liquidator a declaration that they believe on reasonable grounds that the company meets the eligibility criteria. In addition, the liquidator has to give members and creditors a chance to object. Essentially, at least 10 business days before adopting that simplified liquidation process, they have to give a notice to all members and creditors stating that they think the eligibility criteria are met. But nevertheless, they won't adopt the process if at least 25% of creditors object. If 25% of creditors do object, then the liquidator is not permitted to use the simplified liquidation process. In addition, if the liquidator fails to give that notice, again, they can't use it. And in addition, for existing liquidations, it's not available. The liquidator would have to adopt the process within 20 business days of the CVL commencing. In addition, if they're in the simplified liquidation process and they discover through their investigations that the eligibility criteria are no longer met, the liquidator is required to cease using that process. And in addition, if they believe on reasonable grounds that the company or its directors have engaged in any kind of fraudulent or dishonest conduct that's likely to have a material adverse effect on creditors, in those circumstances also the liquidator is required to cease using the process. Now, we've obviously done a very, very quick canter through these reforms. I just want to draw your attention to a couple of resources that will be available. ASIC has a vast array of information on their website, which we've sort of noted on the screen. And in addition, we've included links to both the Act, the regulations, as well as the rules. Now, in addition, Baker's preparing or have prepared a brochure with a comprehensive guide to all of these reforms, which we're very, very happy to circulate. So if you would like a copy, please do feel free to reach out to us on that. In addition, we've got an alert on the temporary relief and statutory demands. With that, in addition, you can always contact one of your friendly restructuring insolvency lawyers from Baker McKenzie. We've included some of our key members on the screen, so please feel free to reach out to them. With that, I might open up to questions. Now, I think Peter's actually addressed most of the questions so far. So at that point, I might bring this presentation to a close and just note that a short feedback form will be automatically open in your internet browser when the session ends, and we'd really appreciate any feedback that you could provide us. Thank you so much for your attention and have a lovely day.